Good afternoon, and welcome to a webinar entitled Teaching Tips for New Law Professors, How to Incorporate Professional Identity Formation in Your Teaching, sponsored by West Academic. My name is Jerry Organ. I'm one of your co-moderators, along with Colleen Medill from Nebraska. We have a wonderful series of presenters with us today. Rick Simmons from The Ohio State University will be talking a little bit about large lecture classes with some particular ideas for crim law and evidence, followed by Lindsey Gustafson from Arkansas Little Rock, who will talk about team-based teaching and using groups and teamwork to support both learning of doctrinal subjects and professional identity formation. Paula Schaefer from Tennessee, apparently the Tennessee, integrating.
I didn't ask for that.
No, we added it. Integrating professional identity formation into traditional casebooks when it may not be there. Miriam Cherry from St. John's, who will talk about using casebooks that have integrated PIF components. And then Angeli St Val from Pittsburgh with some examples for fostering self-understanding using PIF exercises. You might ask, what is professional identity formation? And that's a really good question to ask, right? The ABA revised its accreditation standards in February. The ABA section of Legal Education and Admissions to the Bar revised its accreditation standards in February of 22. They were approved finally by the ABA House of Delegates. And specifically, there's a new standard 303B3 that requires that a law school shall provide substantial opportunities to students for the development of a professional identity. And then the corresponding interpretation, 3035, describes, as set forth in this paragraph, professional identity focuses on what it means to be a lawyer, the special obligations lawyers have to their clients and society. And then importantly, the development of a professional identity should involve an intentional exploration of the values, guiding principles, and well-being practices considered foundational to successful legal practice. And because this development of professional identity requires reflection and growth over time, law schools should assure that students have frequent opportunities during each year of law school and in a variety of courses and co-curricular and professional development activities. So those are the new marching orders for law schools. It took effect officially, or it takes effect officially this academic year. Last year, schools were expected to be developing a plan to do that, and this year they should be starting to implement that plan. So that's where we are. And so a lot of people have been thinking about this. There are a lot of schools that have added professional development courses in the first year. I think we're up over 70 or 80 now that have some type of course in the first year. But a lot of what you're going to hear about today is people wanting to talk about how this can happen in traditional doctrinal courses and in that space. So with that, I want to turn it over to Colleen.
All right. We have a great lineup here. I just want to make two quick comments. The first one is, a lot of people say, well, don't I have to cut coverage to do these kinds of things? And I think people that have done this have discovered that putting students in a role play to help them develop their professional identity reinforces the doctrinal knowledge, and also students retain it better. So I call it the 3 R's. Role playing equals reinforcement and retention. The only other thing is that I want to request if people could leave their questions until the end. We're going to try and save about 10 minutes for questions for the different panelists. So I think with that introduction, Jerry, we're ready for Rick Simmons.
Great.
Let me go ahead and share my screen. Okay, hopefully you can see that now. So first of all, thank you for having me. I'm excited to contribute to this and this great group and these great topics. When I think about professional identity, one of the first thoughts I have is how we train students to think of their job as lawyers, how we train them to think about what they're going to do when they're a lawyer. And at a recent conference, I actually heard our host here, Jerry Organ, describe a survey where law students at about a dozen different law schools were asked to complete the statement, a lawyer is a blank. And the top answer from a large margin was advocate, which kind of makes sense. It reflects to a large extent the traditional way that we actually teach law in this country, right? Especially in large classes. We generally teach law with the case method. That trains people to be advocates. Essentially teaches them that what a lawyer does is they essentially argue cases and they win or they lose those cases. And then sometimes, it also, I guess, teaches other skills like how to read cases and write memos about cases, legal research skills. And those are important skills that obviously law students and lawyers need to have. But as we know, it's a very limited role, limited view of a lawyer's role. Lawyers do a lot of things other than advocate or do case research. Lawyers are counselors to clients. Lawyers draft documents and transactional work. Lawyers negotiate with each other and with others to get a resolution they want. Most of all, lawyers are problem solvers. And to solve problems, lawyers need to have a whole set of skills. And if we're only teaching one narrow set of skills in our large classes, I think that could be a problem. So certainly I still, especially in first year classes, I still do teach students to read cases and to learn the law from those cases. But it's an incomplete way of thinking about what law students need to learn. There's one other point I wanted to bring up before I get into my exercises, and that's the difference between passive learning and active learning. There's another problem I think we see in traditional large classes in law schools. Now, passive learning essentially is when students are absorbing information presented to them. And active learning, by contrast, is when students engage as participants in the learning process by conducting an activity of some kind. So, for example, doing small group work and talking with each other about something, by role playing, by writing something, a reflection of some kind based on what they've heard. Now, both of these kinds of learning are good. They're both useful for law students. Passive learning is very good at transmitting lots of information very quickly. That's something you have to do in law school. It's also good at transmitting threshold concepts. These are disruptive ideas that transform how you see the world. Law students have to sort of grapple with a lot of these threshold concepts, seeing the world in different ways, because now they're thinking about it as lawyers. And passive learning can expose students to these ideas, give examples of this so they can sort of change the way they see the world. That's hard to do with active learning. On the other hand, active learning is better for other things. It definitely is much better for long-term retention of what someone is learning. And it gives you a deeper understanding of the information that you're getting as well. How you can use it in different contexts, use it to solve different problems, and so on. And also, back to the question of developing different skills, it develops different professional skills for students. Not just learning how to read cases, but learning how to be a lawyer in many different ways. So happily, I think the solution to both of these problems, one that we have too much focus on reading, analyzing cases, and one that we have too much passive learning, I think the solution to both these problems is the same, which is to develop and use exercises that engage students either individually or in small groups and puts them in different roles that attorneys might play. So during my large classes, I teach criminal law and evidence. I try and expose students to the different roles that they might have. Now, at first it's somewhat challenging because criminal law and evidence are both very litigation-based. They're both very much people see themselves as advocates when they're criminal attorneys or when they're trial attorneys. But just thinking back to my own experience as a trial attorney, I realized I did a lot of other things as well. For example, I would negotiate a lot as a criminal attorney. I would certainly plea bargain most of my cases and so on. So I thought back to what I did when I was a practicing attorney and thought about how I used different skills, even though I was a trial attorney. I tried to integrate those into my classes. So certainly I did a plea bargaining exercise in my criminal law class. That's a pretty easy thing to set up, I think. I want to talk about two things I did in my evidence class. One is had to do with Rule 609. And for those of you who are not evidence professors, and Rule 609 might seem a bit hazy to you, this is the rule that we use in the rules of evidence when a witness has a prior conviction. And the question is, can you admit that prior conviction to impeach that witness when they testify? And if the witness is the defendant in a criminal case, that becomes an even more tricky question here, right? Because there's an unfair prejudice when the jury hears the defendant has a prior conviction. On the other hand, it has some probative value for impeachment. So how do you balance that? So I could just give them this question. I could just say, here's a fact pattern, apply Rule 609 and the case law to it, and tell me if these prior convictions come in or not. But instead, what I do is I nest that legal question within a counseling simulation that I have. I basically tell them that they are a defense attorney. They're going to meet with their client the next day in the jail, and they have to counsel the client as to whether or not that client should testify in this case. Client has a couple prior convictions. So the first step is the legal question. The attorney has to figure out what are the odds the judge is going to admit these prior convictions or not, and what's going to be the effect on the jury if they are admitted. Then they have to essentially write out the counseling, an outline of the counseling speech that they want to give to this client to tell them whether or not they should testify and to give them that kind of advice. So they do go over a lot of issues that we talk about in evidence: impeachment, unfair prejudice, limiting instructions, how they work, and so on. But they're doing it in the context of planning for a counseling session, and then we can then bring them, have a simulation where someone actually does counsel a client and see how that works, see how the law affects this actual skill that you're doing. And the other example I want to give here for people who are interested in being civil lawyers instead of criminal lawyers is Rule 407. Again, for those who need a reminder, this is the rule that says that subsequent remedial measures are generally inadmissible. If you're a criminal defendant in a civil case and you have a dangerous condition, someone gets hurt and you get sued, and you fix that dangerous condition by changing your protocol or by firing a medical employee or by putting up a banister on a staircase, that fix, that change, is generally not admissible at trial, but it can be under certain circumstances. And so in this case, I take an actual case that is in a lot of case books where a doctor had prescribed medicine to a patient, took the patient off that medicine, and the patient ended up dying. And then the doctor changed their protocol so that they no longer took patients off medication under these conditions. And the question then is, now they're being sued by the family of the person who died. The question is, how do you prepare your witness to essentially defend their old way of doing things now that they've changed it? And the concern is if they actually say too much about how they've changed things, they open the door to their subsequent remedial measure. They open the door to these to their new policy coming in. And once again, I've nested the legal question inside of a skill they have to do, which is think about how to prepare a witness for testifying. And there's plenty of legal issues here that we're going to reinforce from what we talked about when we lectured on Rule 407, without it's a feasibility attack, without we're opening the door. There's also the skill of whether you're prepping or coaching a witness when you talk to them. But these are all things that they're learning as they're doing the skill of preparing to prepare the witness. And again, all students write this preparation at first, and then after that, we come into class, and some of them are going to then do that actual exercise in front of the class to show how they might prepare the witness. So a lot of other examples of this, a lot of ways you can do this in evidence and criminal law, dozens of different kinds of exercises. You can put them in different roles, but I want to make sure I have a chance to get with people to speak, so I'll stop there.
All right. Thank you, Rick. And so next up, we have Lindsey Gustafson from the University of Arkansas, Little Rock. So Lindsey, if you want to go ahead and share your slides. Oh. All right, looks good.
Can you hear me?
Yes, and I can see your slides.
Great. I'm really grateful to join. I'm learning a lot already. I always learn from all of you. I'm going to talk about a technique, less about an exercise, but just some counsel for those who want to use more group or teamwork in their schools. I'm going to give you a little bit of background. Several years ago, my law school, in its regular survey of employers, found that the employers believed that our students lacked adequate teamwork skills. We'd been doing a lot of group work in our classes, but we decided to be more intentional with our teaching and our assessment of teamwork. And so we built teamwork skills into our first year property course. And we've seen some success, and I'll talk about that later. But I want to sit in that place where you decide to make teamwork a learning outcome of your course. You decide to assess it. You decide to make it part of the student's grades. You're dedicating some portion of what you are teaching to teaching teamwork skills. When you do that, you move into a space that is uncomfortable for students, a lot of students. So I want to talk about how, how we've found ways to continue to keep students engaged, to soothe their fears about being in law school and being graded with a team. So why might you think about using teamwork? And why would I say that teamwork is at the core of professional identity formation pedagogy? I have 3 reasons here. I'm sure you can think of many more. These seem to sit right at the core of why I do it. It is an essential professional competency for lawyers. So the vast majority of lawyers surveyed want to hire students who have these skills already. That's 3 out of 4 lawyers say that. 92% of lawyers say that this is an essential professional competency eventually. So it is something that our employers expect students will have when they graduate. It's also something that our students should view as part of being a lawyer. We have also found that collaborative learning increases creativity, problem solving, substantive understanding. Since we started this teamwork focus in our property class, our students have done better in the property questions on the MBE than in any other subject. And that's the only thing that has really changed, is our attention to teaching through teams. Finally, teams provide a really important space for students to work out their ideas of their own individual professional identity. So providing students not only a structure, but the kind of activities that will lead to these discussions with their peers can lead to some nuanced understanding of who they are and what kind of professional they want to be. So it's a really good idea, but do students see what we're trying to do? Do they stay open to the learning that is available through a team? There's an interesting study that I learned about. It's just recent. It came out a couple of weeks ago, where it was a study of undergraduates group learning, and they found that it had a positive impact on students' academic achievement so long as students fully participated. But many students avoided working with the team in any way that they could. They were reluctant to engage with peers that they didn't know. They resented that the professor's role seemed to be decreased. These students who pulled back, either actually physically not attending or just mentally and emotionally pulled back from the experience, did not see a benefit. You can imagine standing in front of a first-year property class and telling these brand new law students that their grade will be influenced by the strangers sitting around them. Absolute panic on probably half the faces. Also, there is a kind of simmering underneath everything is a feeling that I might be wasting their time, and a very low tolerance when they're sitting in a place of uncertainty and panic for time wasting. So I have found a lot of wisdom from the self-determination theory. And I'm going to talk about how to use this theory to design your teamwork so that it addresses these student concerns. So the self-determination theory is used to understand motivation and achievement across a range of contexts. It's used in sports, it's used in professional environments, and it's used in learning. SDT recognizes 3 innate psychological needs: a need for autonomy, a need for competence, and a need for relatedness. So I'm going to go through with, I think I have 5. Yeah, I have 5 specific recommendations of how to use kind of what we can learn from this theory and keep students motivated in the teamwork that you decide to assign. My first suggestion is that you build students' relatedness by keeping them in the same teams for a significant amount of time. It is really important to frame conflict for them. They will be afraid of conflict. They will want to avoid conflict. It is a professional skill, and also understanding they can build about themselves as they move through conflict. And if we are interested in creating relatedness, which is a sense of belonging to the instructor, to their peers, to their future clients, we let them build those ties. I keep my teams for a semester. I can recommend that. Second thing is that we build competence and autonomy by explicitly connecting the assignments we are given to the group, to the course learning outcomes, to the bar exam, and importantly, to the practice of law. So competence is a sense that the students have that they're building skills that are necessary to be successful. They may not see that in the work that you're giving unless you make it clear to them. So it's really important to kind of manage their frustration and their kind of wanting to check out by connecting through stories or through experience how these competence, what they're working on connects with what they will have to do. Autonomy is the need to be in control of one's goals and behaviors. It frustrates autonomy when students feel like we are wasting their time. 3, we can build competence by having students complete significant team tasks independently first, and then inviting reflection after they join with the team. This is really important because, of course, they take a final exam by themselves, not with the team, and they will, of course, practice probably not with the people who are sitting around them. So they need to feel an independent competency. So it's important that students do everything independently and then come together and talk and compare. It's also important that they don't get a false sense of what they can do. You invite reflection back after the team experience. What have they learned? What will they change about what they do independently? That builds competence. 4 is build autonomy by respecting students' time. Last night, I taught property. I explained the structure of the course to them. I said, what are your concerns? And the first thing they said was, I don't have a lot of time outside of class to meet with a team of students. We do our teamwork in class. They work independently outside of class. They come together and I respect their time. We've got busy students. It frustrates them to have to coordinate with other students who may not understand their commitments. And the fifth recommendation I have is to build autonomy by providing a peer review system that ensures accountability and reflection. This I find you have to very aggressively encourage and enforce because they do not want to review each other. You protect their identity so they don't have a direct responsibility that might lead to conflict, but they need to be accountable to each other. Finally, I want to recommend team-based learning specifically as a method to accomplish these goals. This is what we have used. We have found it to be incredibly helpful in really answering all of those concerns and keeping our students motivated. You can go to Westlar Lexis and look for team-based learning. You can Google it. There are so many resources out there, and I'm happy to be of help. And I am done.
Okay, thank you, Lindsey. Next, we're going to have Paula Schaefer at the University of Tennessee. So, Paula, do you want to go ahead and share your slides?
Hey, thank you. Actually, I don't have any slides, so I'm just going to talk today. Thank you all for sharing too. I learn a lot every time I'm with this group, and part of what I want to talk about today is sort of the soul searching I have done, and along with my colleague Joy Radice, as we teach a professional identity course in the first year and think about how to incorporate professional identity issues into other classes, really guided by the Holleran Center and the conversations we've had there. We've thought about looking at the things that our school has already said about the values and standards that we think are most important, and think about how we highlight those standards as we talk about professional identity. In the first year, we have a standalone class, and as we incorporate it into other classes. And I think Jerry's introduction is a good one. Standard 303 says some things about what we mean by professional identity, but it doesn't say everything. And there's an article that is on the Holleran Center site. I don't think it's attributed to a single author, but a Holleran Center production that I want to quote really quick. It says, as a school thinks about its professional identity curriculum, it should look inward. Each school should emphasize the professional values that align with its mission and objectives. And I guess I would say to professors, if you're not sure what everyone means by professional identity, spend a little time looking at what your school is already saying about it. Joy and I spent some time doing that this summer because we wanted to make sure we were on the same page with our colleagues and thinking about the issue. We looked at our strategic plan, we looked at our school's learning outcomes, we looked at graduation requirements, and the list we came up with is not, the only aspects of professional identity, but I think it is a touchstone for me as I think about the things I want to emphasize in classes. They are serving clients, leadership and service to our communities, attorney well-being, cross-cultural competence, professional growth and planning, and fulfilling standards of professional conduct. So that encompasses a lot, and it's certainly not everything, but those are statements that we can find that have been made by the University of Tennessee. And so it makes it easy for me to point to those things as I talk to students about issues of professional identity. And I think for any professor just thinking about what they're going to incorporate into their own class, it can be daunting to think, where do I even start? That's so many things. I would think about your school's list and think about the things that you're most interested in talking about and look for opportunities to talk about those things in the context of what you have planned for the class. The thing I'm specifically going to talk about today is how you can use your current casebook and integrate some of these professional identity lessons without doing a lot of extra work. And I know that we always hear doing this is going to displace doctrine. I think it just helps enhance doctrine, and students learn this material better when you can do something to connect what they're studying with what they're going to be doing in practice. So I have a list of 5 tips until Jerry cuts me off because I've run out of time. So either I'm going to get through 5 tips or Jerry is going to tell me that I'm done, or Colleen.
Oh, Paula,
Are
Jerry
you already
left.
cutting me off?
Jerry left, and I'm not cutting you off. You're fine. Keep going.
All right, I'm gonna keep going. Well, one thing that may sound like I'm encouraging you to adopt another book, but doesn't necessarily have to be the case, is put your students in the role of lawyer, even if you're just using a traditional casebook, by introducing hypotheticals or maybe some longer simulations at the entry point of each topic of a class. So for me, that means even if I'm not doing a lengthy simulation exercise outside of class, I'm going to provide students with some kind of hypothetical at the beginning of a subject that puts them in the role of lawyer and requires them to kind of think through that issue that their lawyer is thinking as they read the cases for that part of the book. So for example, I'm temporarily teaching civil procedure. I was supposed to not teach it this semester and needed to step in for someone. And even though I hadn't planned ahead of time to teach that class, it's so important to me that students be put in the role of lawyer that I found a way for them to interview a real client on the first day of class as they started thinking about drafting a complaint. And I also want them to draft a complaint in civil procedure. I don't think it displaces doctrine. My students understand a lot more about Twombly and Iqbal after 3 classes than they otherwise would by doing that. And the bonus is I can talk about a lot of professional identity things. And it's not obvious, like, oh, we're going to pause and talk about professional identity now as we get ready to interview this client on the first day of class. We talk about how are you going to make her comfortable so she will be able to trust you and tell you everything. And we work through those issues, and they've learned something about professional identity without knowing that they were. So I do that the entire semester in all of my classes. I always do something to put them in the role of lawyer, even if it's not a lengthy exercise. Another thing I recommend is to look for the lawyers in your cases, not necessarily the litigators, but the lawyers in the underlying matter. I teach business associations. I always look for the lawyers who advise the underlying conduct, look for the clients in your cases, and ask questions about them, talk about when they got it right, when they got it wrong, what hints there are. I also teach professional responsibility. There are often lots of hints that the clients weren't happy with the representation, but I always talk about the lawyers and clients in the cases. And again, I don't pause and say, we're now going to do something that's professional identity focused. We just talk about it as part of the class. Another thing I would say is, don't be afraid to invite a guest into your classroom based on something that you're doing in that traditional doctrinal class. An example of that, we had a case that we studied in civil procedure that involved a judge that was here in Tennessee who called lawyers in an opioid case out for lying and wrote an opinion that said, like, this is their first lie, this was their second lie, and enumerated the number of lies that this firm told to the court. And I thought, like, what an opportunity to have a judge come and talk about why he felt that that was necessary in that case, and what he thought led those attorneys to do that, and what lessons he hoped they gained from that experience. And the case was over. The judge was happy to come. He came by Zoom, and that's another good lesson. We've all learned from COVID, you can do things by Zoom that we wouldn't have thought of doing in the past. And I think that those are always, I mean, for better or worse, they're the classes your students will write about in the evaluation and remember. So they didn't remember anything you taught them all semester, but they did enjoy the day that that special guest came to class. I've done that with well-being issues. I've had someone come to 2 different classes in the past year to talk a little bit about mindfulness and breathing and how that can impact our wellness as attorneys and our performance as attorneys. So yes, think about that. And I think it really does make for a fun class to have someone else join you. Am I out of time?
You're out of time.
That's fine.
Okay, we're gonna, but we do have the question and answer session.
That's okay.
End. So now we're going to have Miriam Cherry from St. John's University talk to us about casebooks that actually integrate professional identity formation exercises. So Miriam, you want to go ahead and share? I know you do have slides.
Yes, thank you so much, Colleen, for the introduction. I'm going to go ahead and share. All right, so I am going to be talking a little bit today about these subjects, about thinking about these subjects in the context of using a book that does include these. And so I'm going to be talking about, sorry, I'm going to skip slides here. I'm going to be talking about specifically my own book that I worked on, which is Contracts, a Real World Casebook. And I was thinking about this. It's something that I ended up thinking, I've been thinking even more about. And so it's such an important topic, and where I think it fits in, if we're thinking about working on course design and thinking about how we want our courses to go. Of course, on the right-hand side, we want to think about content, substantive knowledge, what your law school requires, and some of the other pieces that in a first-year course you need to know and you need to have. On the other hand, on the left-hand side, we want to think about where we want to be going also, and that includes things like trying to figure out what knowledge and skills beyond just only the content or only the bar outcomes, and then working backwards from the desired outcomes to try and get there, as well as your assessments to build towards those goals. And I would put professional identity formation into this column that we have on the left-hand side. I have it at the bottom, but it's not really at the bottom. It's integrated in all of the other pieces that we want to do. And so in thinking about how to include things and why we do this, I'm going to sort of call back to Rick's earlier comments about how when you do professional identity formation within the book, you're inviting students to engage in more active learning processes. And that's what we all want to see, is have everyone's hand raised, right? That's what we would like in our classrooms. And that's because when people are engaged and participating in this, this was Lindsey's discussion of group work as well, when people are actually really invested or engaged, then they're going to get more out of it. And it does mean that students are going to be thinking more about their role as lawyers and where they're going with all of these maybe very abstract doctrinal concepts. So in my book, I tried to do some of this engagement by including some things that are very pop culture related. And I did that because there's so many celebrity contracts that you can actually use that are great examples and that students love to talk about, and it gets them excited about the subjects. But the other thing that I've tried to do is to try to put students into the role of into the roles of lawyers, just the way that Paula was talking about in the last presentation. So I'm going to use two examples from my from the casebook, from my book, that I talk about unconscionability, and I ask students to really put themselves into a role thinking about this, and they are not the easiest questions to answer. So the two examples that I would give under unconscionability, first of all, would be the payday loan exercise that I do. So I ask students to, I've done this in the past, ask them to actually go out and physically visit a payday lender, but I've also had them look this up online. So go try and take out a loan online. What information would you need? And then this leads to a lot of questions once students do this, right? Well, what actually are the terms that are being offered? They're usually terrible. Who borrows money in these circumstances? Why would you agree to a loan on those egregiously bad terms? What does that say about your bargaining power in that situation? And so then it sort of leads into questions about, as lawyers, how can you articulate the circumstances under which these kinds of contracts either should or shouldn't be enforced? And so I asked them to think about this from more of a policy perspective, or what would they do if someone came into their office and told them about what they were facing with having taken out one of these loans. And then we get into nuances. For example, you can't have one of these payday lenders located on a military base or near a military base, and there's other kinds of laws that might apply. The other context in which I bring this up related to unconscionability has to do with rent-to-own furniture, and this relates to that classic casebook classic, the Williams versus Walker Thomas furniture case, which actually I had more in the squibs to a more modern case that really presents the issues really front and center about some of the problems with mortgage lending. But in that case, in Williams versus Walker Thomas furniture, they had a dragnet clause that enabled the furniture company to repossess all of Mrs. Williams' furniture because of one default on a small item. And this was known as a dragnet clause. And Judge Skelly Wright in 1965 ruled that these kinds of dragnet clauses were unconscionable in these credit purchase contracts. So in the example that I have in the book, I have a furniture store owner approach the student, who's now an attorney, and ask them to write a dragnet clause into the contract. This is presuming that there has been a ruling like Skelly writes in the jurisdiction. And they ask for it to be inserted in tiny font at the end of the contract, and they even say that the purpose is to scare the customers. And I present this to the class and ask, what should the attorney do? And I don't know. I mean, the thing is that students often are perplexed by this and confused. Well, you know, if the client wants me to do something, at what point do I determine if that's actually not in their best interest? Do I push back on this? What kinds of issues or duties do I might have to unrepresented people? Maybe the purpose might not be right, but is there a way to modify the language somehow to do what they want it to do, but not write an unconscionable term into the contract? These are all things that I'm inviting students to do, even if at first they don't want to push back and they don't want to answer. So what I would say is, as we're talking about this, our time is limited and I'm wrapping up. But what I would say is that there's many available resources on this, and you should check the teacher's manual for your books and see what they talk about in terms of trying to set up hypothetical situations or questions that really raise legal ethics issues front and center, or the role of the lawyer that we were talking about. You can ask for other resources too, of course, right? Many authors like myself are happy to share things like our PowerPoints. Some of us really love to talk to new professors or experienced professors who are teaching the subject for the first time. So get in touch with us, talk with us. We love talking about our subjects. So I'm just going to leave it with this quote. Education is not the filling of a pail, but the lighting of a fire. And I will, with that, I will leave it there. Thanks so much.
Okay, thank you, Miriam. So last up, but definitely not least, we have Angeli St Val from Pittsburgh. So you want to go ahead and share your screens and take it away.
Thank you so much, Colleen. And you got it right.
Yeah, I had to practice your name, but I got it.
Thank you. Let me share my slides. So I am Angeli St Val from the University of Pittsburgh School of Law. And what I want to talk about is really how do we foster self-understanding in our courses, particularly in legal writing or smaller seminar classes. They provide really good opportunities to have students really pause and think about who they are and who they want to be as lawyers. And so the two exercises that I will discuss will do just that. They will guide students and help you in guiding students in fostering their self-understanding. So the very first is the culture box assignment created by my colleague, Ann Sensheimer. This is the very first thing that I do in my legal writing classes every year, and I really look forward to it. So 2 weeks before classes start, I send out the assignment to students with a reminder 2 days before classes, because inevitably they'll forget. So I explain that to them that the law is in many ways like studying another culture, and that they will often feel as though they're learning a new language with unfamiliar vocabulary and a different style of communication. So I tell them that the study of law is both engaging and frustrating, and may even challenge some of their values and belief systems. So, which is why it's a good place to start with an exploration of their culture box. So students are told to prepare a culture box to present on the first day. They're asked to bring 2 to 3 items that focus on really the following areas. So the first is things that represent who they are, which may include significant events or things that have really shaped their view of the world. The second is things that represent who they are in a professional sense or illustrate significant past experiences or awarenesses that have led them to study law at this particular time. And the next is things that represent what they think about law school and the legal profession and their vision regarding legal education. So the items can be tangible or it can be metaphorical. They can run the gamut, and students really get to choose. So it gives them a chance to really be creative, but importantly, it gives them a chance to reflect at the outset of their academic journey on the things that are at the core of who they are and why they're entering the profession. It also has the added bonus of allowing me to get to know them. So students have 3 minutes to present their culture box in class. They also write a 500-word reflection on what they included in their culture box and why. I also asked them to share in the writing what they thought about what would make them a successful law student, and how at this moment they imagine using their legal education. They also reflect on their perceptions of their colleagues and really the class as a whole. So this is absolutely one of my favorite things. I also present my very own culture box. So I set the tone and start, and then students present theirs as well. The next assignment is really, it's a values exercise that can work, again, in legal writing classroom or smaller seminar courses. And I really learned this from working with Dr. Omi Fatui, a psychological researcher. And this, you start really by asking students to name 5 to 10 people they value and admire, and then to use concrete words to describe these individuals. Then using those same words, have them craft a description of what they stand for, thereby creating their value statement. If you ask students to just create a value statement, they won't know where to start. So asking them to focus on 5 to 10 people who they admire really helps to, really focus them in. So this gives them an opportunity to reflect again on who they are and what they stand for, which is something most students have not had the opportunity to do. So the more they know what they stand for, the less likely they are to experience dissonance, or at the very least, they're able to recognize when what they're asked to do conflicts with their values. So once they have this value system, then take a step further by then coupling this exercise with an examination of a case that you've pre-assigned or something they've already read. So this case should have a complex problem or litigant. So again, review the facts and issues like normal, but then ask students to really think about how they would decide whether they would take on a case or represent a particular party. So looking at their value statement, is this the case they could or would accept? What other things would factor into their decision making? So similar to what Paula mentioned, what about their professional obligations and their oath as attorneys, or their own family and personal obligations? How do those align? So when I have done this, it's really led to a discussion on various positions that allow a certain value system. So students really enjoy getting the opportunity to discuss how the past in the law will align with their values and who they are at this moment. So you want to be sure to let students know that there is no right or wrong answer. These are simply, things that they should think about as they make their decision, because a lot of this we do unconsciously. So being consciously aware helps with some of that dissonance. So these are just 2 exercises to consider when guiding students and thinking about their professional identities. You can find more about that. You can contact me should you have any questions. There's also in our forthcoming 3rd edition of the Legal Writing, A Contemporary Approach, we have more exercises relating to professional identity and ways to incorporate that throughout the year. Thank you very much.
All right, well, that completes our formal presentation. If people have questions, you can go ahead and put them in the chat or unmute and ask your question. While we're waiting for questions though, Andrele, I do have a question for you, and I'm just wondering, have you ever had students say, I didn't know I could refuse to represent a client? And do you have those kinds of discussions?
So we do. So we explore when you can say no, and if your circumstances allow you to say no, because that's something else that factors into that. So it really leads to a robust discussion, about the types of jobs you use, where you choose, firm life, public service, and how those align with values versus obligations, personal, family, student loans. So yeah, it's a really fun exercise, and it gets students to talk about the things out loud that they're thinking about in the back of their, in the background.
Well, that's probably a topic they should think about sooner rather than later in their law school career. So I love that. Miriam, I have a question for you, and this relates to a personal experience I had assigning a professional identity exercise. Do you ever have to tell the students not to go out and investigate something on their own, and that they may go too far? In my situation, I had a property issue. I think Lindsey will love this. And I tried to disguise and make the tracks that were involved anonymous. And then I got a phone call from the dean because apparently my students had found where this property was located, and they were out trampling all over it. And the owner said, "What are you doing here?" Well, this is an exercise for Professor Medill. And so I didn't know. I thought you sending them out to payday lenders was kind of interesting. Do they ever come back with some interesting stories from that?
They do come back with interesting stories. It mostly involves, let's start a petition and write to our congresspeople and try and do something because this is terrible. And we feel like people are getting ripped off, which, isn't really the purpose of necessarily why I'm sending them out there, but is an interesting byproduct that people develop a sense of activism by looking into it. So that may be, an unintended consequence, but is a good one. It's true that when you ask people to go out and investigate things, you're right, Colleen, you do have to be a little bit careful, because because we wouldn't want them maybe doing things that are overstepping the boundaries, literally in your case of going onto
Trespassing.
someone's land. Right, we don't want them investigating, a tort on its own, or trespassing or something on its own. I haven't had that issue. It's more like it has raised their political view or their consciousness about certain issues, and has made them want to become more activist on certain issues, I would say.
Well, that's also part of professional identity. So I think that's great. So now, Paula, I know you've done a lot of innovative things with professional identity. And I think I've heard you talk about, you did have a guest speaker to talk about wellness with students. And I'm wondering if you could just share a little bit about that. You've brought in wellness people, you've brought in social workers who told you that the clients didn't need help so much as the anxious students did. So do you have anything that really stands out in your mind from one of those guest speakers? Maybe something you didn't expect would happen that then just magically happened?
Muted, sorry. One thing that has resonated with students is when you bring in attorneys to talk about their own wellness journeys. And we brought a couple of attorneys to our big 1L class with all of the students to talk to them about what they did to work on wellness in the law offices where they practiced. And one was a defense side lawyer and one was a prosecution side lawyer. And I think that they, that really resonated with them, the similar things that they both did to take on wellness for themselves personally and try to make a difference in their offices. And I think we got more emails from students afterwards asking to reach out to those alums and lawyers because they wanted to ask them follow-up questions. So we've brought professionals, we've brought social workers, we've brought therapists, we've brought like a mindfulness-based stress reduction expert who teaches MBSR classes. And all of those, I think, are really appreciated too. We're just at the 1L stage really trying to plant the seeds. I think get people thinking about what they can do and get excited about it.
Yeah, well, it's never too soon to start working on those things, I think. So we do have a question from the audience in the questions and answers, but I am not able to pull that up. So either Rick, you're the one that called it to my attention, if you want to read the question, or if the person who asked the question just wants to unmute and ask it, either way would be fine.
Yeah, and as for the 5 tips, so listed out briefly to start with the introduction of hypothetical, the beginning of the subject. I forgot which of you, that wasn't me, so I forgot which of you.
Oh, I think that was me. So I think the ones I didn't get to, I was going to say, think about including a book group in your class. Pick a book about a lawyer that has a connection to your class and read it, and maybe make it optional, maybe make it part of the class. I grabbed one that I have done before in professional responsibility. It's called The Long Goodbye by Bill Colby. And he tells this story about representing Nancy Cruzan's family from the time he was an associate in a law firm. And he ended up arguing the case at the US Supreme Court, and what a great pro bono experience it was. It changed his life. And then the other one that I didn't get to talk about was just not downplaying the importance of professional conduct rules. I think sometimes there is this idea that we will just tell students, push that to the side, and professional identity is doing more than the rules require. But remember, the rules implicate all sorts of things in a lawyer's professional life. So when you see those issues in your casebook, research them, figure out what the answer is, talk to your colleagues. But don't just put that to the side and say those are issues that you don't need to worry about, or assume that students know the answer, because I think those are times that students get in trouble when they just think, I'll just do the right thing, and don't realize they're doing something. Those are, as a PR professor, those are the phone calls I get sometimes too, where somebody gets into hot water because they did something that violated a rule when they thought they were just doing the right thing.
Interesting. Well, I have a question that's both to wrap up here for Lindsey and Rick. And I'm wondering, in terms of large classes and working in teams, if there isn't a big difference between a 1L class and an upper level class. And part of this draws on my own experience. When I'm teaching 3Ls in real estate transactions, they don't want to sit and listen to a lecture. They would far rather write deal documents, and I let them form teams and I give them a simulation, and they really like it. So I'm just wondering about your experience with that. I know, Lindsey, you really addressed the 1L situation. Rick, in some of your upper level classes, do you feel like you have to address anxiety issues, or are the students just raring to go and do something other than the Socratic method?
Do you want to go?
Yes.
I mean, Lindsey can go first if she wants, or I can go. I don't know. Okay. So yeah, I definitely think that as I agree with your comments, your question, that as the students get further along in law school, they're much more less reticent and much more eager to engage in these kind of small group exercises. You know, I don't think I've ever tried a small group exercise in the first few weeks of my first year crim law class. I think that might work, it might not. Part of my theory is that this reinforces law that they've already learned, and so I don't think it's always a good way to learn material for the first time in small section or small group work. I think they're supposed to be reinforcing what they've already learned before, so you have to get some basis for that. But I also think that there is some value in first years, you know, getting a lot of material through non-small groups, and then later on in the semester I use small groups for that. By the time we get to the second, third year, yeah, the students want nothing better than to actually be simulating, practicing law, working in small groups, not saying listening to us. They've done that for a year or 2 years already, and so I think they're much more eager to participate in these small groups.
Great. Lindsey, do you have anything you want to add to that?
Just real quickly to kind of confirm what you suspect about the level of anxiety decreasing. You know, what they don't seem to get better at is understanding how to work with other students and recognizing that as a distinct skill and kind of grappling with their strengths and weaknesses in that space. So I think there's still plenty to kind of frame up for them. But you're right, kind of clearing the deck and making space for this is real work. I'm showing you what you'll be doing when you graduate or when you pass the bar and you graduate, is important. It just needs to be coupled with an attention to the skill, because they may think that they're just fine and they have some learning to do.
All right. Well, on that note, we are going to leave you with some resources on professional identity. If I can get this to advance here. I think my computer might be a little stuck. Let me see here. Well, all right. It looks like I've been frozen. But I would encourage everybody who's listening to look up the Halloran Center for Ethical Leadership. And I see people nodding here. This is at the University of St. Thomas. And if you scroll down, you will see they have an absolute wealth of resources on professional identity formation. So the Halloran Center for Ethical Leadership, I would highly recommend it. It really will open your eyes to all the things that people are doing in this space. So with that, I think we are finished. And so thanks everyone for listening. This has been great.